Excellencies, ladies and gentlemen, good morning. I declare open the roundtable on legal aspects of the question of Palestine, convened by the Committee on the Exercise of the Inalienable Rights of the Palestinian people. Mr. Michael Mueller, Acting Director General, United Nations Office at Geneva, representative of the Secretary General, Mr. Anders Kampas, Director of the Field Operations and Technical Cooperation Division, Office of the Human Rights Commissioner, representing Madam the High Commissioner, Mr. Isa Garachi, Minister for Prisoners' Affairs, Palestinian Authority, State of Palestine. Excellencies, ladies and gentlemen, on behalf of the Committee on the Exercise of the Inalienable Rights of the Palestinian People, I'd like to welcome you to the first meeting, round-table meeting of our committee, organized in line with Resolution 68/12 of the UN General Assembly and devoted to the legal aspects of the question of Palestine. Now, with the organization of this meeting, the committee would like to, during this period of time that is full of challenges, to look at a number of issues related to Palestinian prisoners and detainees, respect of international law and the responsibility of third states, the status of non-member observer state of Palestine, and also the options that the state of Palestine has before international courts. Now, this round table will help us look into all of these issues in light of current events, and also we will be referring to numerous events that will stress the importance of provisions of international law in the efforts aimed at finding a comprehensive, just, and durable solution to the question of Palestine. Now I have the great pleasure to welcome Mr. Michael Mueller, Acting Director General, United Nations Office in Geneva and representative of the UN Secretary General. And Mr. Mueller, the committee highly appreciates the fact that you're participating in this roundtable despite your very heavy agenda, and I have the pleasure of giving you the floor.
Merci. Now
Thank you.
my honor to deliver the message of the Secretary General, Mr. Ban Ki-moon. And I quote, "I am pleased to send greetings to all the participants in this roundtable on the question of Palestine. I thank the Committee on the Exercise of the Inalienable Rights of the Palestinian People for organizing this discussion. The round of peace negotiations, being led by the United States, offers an opening to advance the two-state solution to the Israeli-Palestinian conflict. Most importantly, the Israeli and Palestinian leadership committed themselves to 9 months of focused talks on all core permanent status issues. However, given the complexity of the issues, 9 months have proved to be insufficient to complete the task. I urge the parties to continue the talks on substantive basis beyond 29 April. The costs of walking away from the negotiating table would be exponentially higher than the pain of the compromises required to resolve the conflict. No lasting peace can be achieved away from the negotiating table, and in the current situation is not sustainable for both parties, the region and the international community. The establishment of an independent state of Palestine based on the borders of 1967 alongside a secure state of Israel is long overdue. The suffering of millions of Palestinians under occupation has lasted far too long. I remain deeply troubled by Israel's continuing settlement activity in the West Bank and East Jerusalem, which is illegal under international law. Settlement activity is deepening the Palestinian people's mistrust in the seriousness of the Israeli side about achieving peace. It also risks rendering a two-state solution impossible. The peace efforts are also being hindered by violence and incitement from all sides. I am concerned over the rising tension with respect to the Temple Mount Haram al-Sharif in Jerusalem, and call on all parties to show utmost restraint as well as full respect for the sanctity of holy sites of all faiths. The deteriorating condition of Gaza's civilian population remains a source of alarm, as the 7-year-old closure continues to cause serious humanitarian consequences. More than 80% of all families in Gaza are dependent on aid, yet Gaza remains subject to severe restrictions on imports, exports, and the movement of people by land, air, and sea. I call for a complete opening of crossings into Gaza, including Rafah, to allow legitimate trade and movements of people. At the same time, Israel's legitimate security concerns must be addressed by continuing to thwart militant attack and prevent the smuggling of weapons. I also reiterate my condemnation of indiscriminate rocket attacks from Gaza, which contravene international law. Israelis have a right to live free of cross-border violence. I welcome the desire of the organizers of this conference to highlight some of the legal aspects of the Palestinian question. I have repeatedly expressed concern for the more than 4,000 Palestinian prisoners held by Israel and have also called for ending the practice of prolonged administrative detention. I have also called on Israel to abide by its legal obligations as expressed in the advisory opinion of the International Court of Justice on the wall and the settlements. I will continue to do my utmost to support the realization of a two-state solution. I am pleased to continue to be assisted in this endeavor by Mr. Robert Seri, the United Nations Special Coordinator for the Middle East process. We urge the international community to support both sides in continuing their negotiations with the aim of reaching a final peace settlement. I wish you success in your deliberation. This thus concludes the message of the Secretary General, and allow me in closing to underscore the Secretary General's wishes and wish you a fruitful discussion and a productive roundtable. Thank you very much.
Je remercie M. Muller.
I'd like to thank Mr. Muller, and I'd like to express my deep gratitude for the hospitality that he has demonstrated and his unswerving support in the preparation and organization of this meeting. Now, I'd like to make a statement as Chairman of the Committee on the Exercise of the Inalienable Rights of the Palestinian People and Head of the Delegation of the Committee. Excellencies, Mr. Issa Garahi, Minister for Prisoners Affairs, Palestinian Authority, Mr. Michael Muller, Acting Director General, United Nations Office in Geneva, Mr. Anders Campos, Director of the Office of the High Commissioner on Human Rights, representing the High Commissioner. Ladies and gentlemen, on behalf of the committee, I'd like to welcome you to the first roundtable on the legal aspects of the question of Palestine. The committee would like to express its gratitude to the government of Switzerland and the United Nations Office at Geneva for the warm welcome that has been extended to the participants in this roundtable. Remember last year, the UN General Assembly in Resolution 68/12 declared 2014 as the International Year of Solidarity with the Palestinian people and requested the committee to organize activities that will be taking place during the course of this year in cooperation with governments, United Nations organizations, intergovernmental organizations, and relevant organizations of the civil society. The objective of this year is to raise awareness in the international community to the main aspects of the question of Palestine and promote peace between Palestine and Israel, while drawing attention to the obstacles that undermine the peace process that is now ongoing, especially the settlement colonies, the status of Jerusalem, the blockade of the Gaza Strip, and the humanitarian situation in the occupied Palestinian territories. The committee welcomes the sustained diplomatic steps that are taken by the international community, especially the persistent efforts of the United States Secretary of State, Mr. John Kerry. At the same time, I'd like to call upon all parties to act in a responsible manner to create a climate that will be helpful to fruitful negotiations, which in turn will help resolve the questions related to the final status, to put an end to the Israeli occupation, to ensure the complete withdrawal of Israeli armed forces from Palestinian territory occupied since 1967, including East Jerusalem, and in the end, allow the Palestinian people to exercise their inalienable rights, especially the right to self-determination. Nevertheless, despite the appeals launched by the international community to Israel to end its settlement activities, the extension of the colonies, which is accompanied by the destruction of Palestinian houses and the expropriation of Palestinian territory, is continuing at an alarming rate in the West Bank, including East Jerusalem. The construction of these settlement colonies in the occupied territories has doubled between 2012 and 2013, and these acts are flagrant violations of Articles 49 and 53 of the Fourth Geneva Convention.
Le 29 mars, Israël
On March 29, Israel failed to meet its commitment to release to the fourth group of 26 Palestinian prisoners, part of the agreement with the U.S. and Palestinians that led to the resumption of talks. The decision not to release this fourth batch of prisoners have further complicated the continuation of the political dialogue. Given these harsh realities, it is a rather fortuitous coincidence that we find ourselves in Geneva today. The General Assembly demonstrated solidarity with the Palestinian people by adopting its historic Resolution 67/19 on 29 November 2012, recognizing Palestine as a United Nations non-member observer state. This recognition enabled President Mahmoud Abbas to sign 15 letters of accession to international conventions and treaties on April 1st, including a letter to the Swiss authorities in their capacity as depositories of the four Geneva Conventions of 12 August 1949 and its first additional protocol. The Geneva Conventions define the basic wartime rights of prisoners, both civilian and military, in times of war, establish protections for the wounded, and also establish protections for the civilians in and around a war zone. Moreover, the Geneva Conventions also define the rights and protections offered to non-combatants. The State of Palestine formally acceded to these conventions effective 2nd of April 2014, a day that will be remembered by future generations as momentous. During the next 2 days, together with our Palestinian colleagues and the high-level panel of legal experts who accepted our invitation, we'll be learning a great deal about the application of the Geneva Conventions to prisoners held by the occupying power and applicable international mechanisms. We'll also hold discussions about the broader legal implications of Palestine's accession to international conventions and treaties. This is critical since if the current round of negotiations fail, the Palestinians will have other legal options open to them. I encourage all of you to participate actively in the discussions to make it possible for our Palestinian colleagues to start to exercise the full depth and breadth of their inalienable rights. I look forward to 2 days of fruitful discussions. Thank you very much.
Excellences, Mesdames et Messieurs.
Your Excellencies, ladies and gentlemen, it's now my pleasure to wish a warm welcome to Mr. Anders Kompas, the Field Operations and Technical Cooperation Division Office of the Human Rights Commissioner, Deputy Director, and representative of the High Commissioner at this meeting. Mr. Kompas, you have the floor.
Mr. Chairman, Excellencies, colleagues, ladies and gentlemen. I'm honored to represent the High Commissioner for Human Rights in this roundtable, and I would like to extend her thanks to the committee for convening this event. There have been significant developments in recent times regarding the situation in the occupied Palestinian territory. The formal recognition of Palestinian statehood by the General Assembly is a significant step towards Palestinians' realizations of the right to self-determination. The High Commissioner, as well as her predecessors and many of the United Nations human rights mechanisms, have consistently called for the right to self-determination of Palestinians to be respected, protected, and fulfilled. This is a fundamental right, human right, one to which Israelis and Palestinians are equally entitled. Many key human rights concerns related to the occupation of Palestine were highlighted in the reports of the High Commissioner and the Secretary General to the recent 25th session of the Human Rights Council. These need to be addressed urgently, regardless of the outcome of the current round of peace talks. In the West Bank, including East Jerusalem, concerns include the excessive use of force against Palestinians by Israeli security forces, violations of rights of Palestinians deprived of their liberty, the ongoing constructions of Israeli settlement and settlement-related activities, such as the demolition of Palestinians' homes, forcible transfer of Bedouin communities, and settled violence. The situation in the Gaza Strip has been of equal concern to the Office of the High Commissioner for Human Rights. Israel's blockade of Gaza, which constitutes a form of collective punishment prohibited under international law, coupled with the recent destructions of most of the tunnel network with Egypt, has resulted in a significant deterioration of economic and social rights in Gaza. In addition, the renewed hostilities between Palestinian armed groups and Israeli armed forces in the Gaza Strip in recent months are troubling. An overarching concern which affects the entire spectrum of Palestinians' economic, social, cultural, civil, and political rights has been a lack of accountability on both Israeli and Palestinian side. As recalled by the High Commissioner at the latest session of the Human Rights Council, there is an urgent need to carry out prompt, thorough, effective, independent, and impartial investigations into allegations of unlawful killing, of injury and torture, and ill treatment, and to prosecute individual responsibility for violations and provide victims with an effective remedy. It is past time that human rights of Palestinian and Israeli alike be respected and international obligations be observed. This is imperative for any lasting peace. In the context of the current talks, the parties need to do everything possible to respect human rights. I am pleased that the 2 days of this roundtable will be used to discuss many important questions. My colleague, Mr. Heenan, will be making a presentation in session 1 focusing on how United Nations procedures and mechanisms have addressed the human rights concerns related to Palestinian detainees and prisoners. The session on Palestinian status as a state promised to be a very interesting discussion. The recognition by the General Assembly of Palestine as a non-member observer state has opened the door for Palestine to accede to international instruments. Much has been said about the recent decision by Palestine to request accession to a number of international treaties, including 8 human rights instruments. However, it is a positive development that Palestine has acted to formally commit itself to the international human rights principles and standards contained in those instruments. I would like to thank again the committee for this initiative and look forward to the 2 days of fruitful discussions. Many thanks.
I thank Director Compass for having agreed to represent the Office of the High Commissioner for Human Rights at this important meeting. OHCHR is a natural ally of the committee, and I would highly commend its activities at an institutional level and in the field. The office carries out crucial work of high quality. I thank Mr. Compass again for having come to be with us and for having made this important contribution to this round table. Your Excellencies, ladies and gentlemen, Now it is my honour and pleasure to wish a warm welcome to His Excellency Mr. Issa Karake, Minister for Prisoners' Affairs of the Palestinian Authority and representative of the State of Palestine. I would like to pay tribute to Mr. Karake's work. He is a fervent supporter and great friend of our committee, and we cherish his cooperation with us. You have the floor.
سعادة السيد
Mr. Abdulsalam Diallo, head of the Committee on the Exercise of the Inalienable Rights of the Palestinian people, Mr. Michael Muller, Mr. Anders Kompas, Excellencies, ladies and gentlemen, good morning to you all. At the outset, I would like to convey to you the greetings of President Abu Mazen, the head of the Executive Committee of the Palestine Liberation Organization. I convey to you also his appreciation and thanks for organizing this important meeting under the aegis of the United Nations, wishing you every success on the path to love, peace, and justice, with a view to ending the longest-lasting occupation in history against our Palestinian Arab people. I also convey to you the greetings of our Prime Minister, Dr. Rami Hamdallah, who hopes that this meeting will further help achieve justice and human rights. We look forward to a day where our people will achieve self-determination and freedom in line with successive United Nations resolutions. I also convey to you the greetings of our Palestinian people at home and in the diaspora, the greetings of the families of detainees and prisoners in Israeli prisons and camps who hope that the world will put an end to their suffering and offer them international protection under the umbrella of international humanitarian law. On my own behalf and on behalf of my colleagues who represent human rights organizations in Palestine, we would like to express our thanks to you and to the head of the committee for organizing this important meeting at this time where the occupied state of Palestine has become a high contracting party to the 4 Geneva Conventions, as well as a party to 15 international treaties and conventions. Ladies and gentlemen, there are still 5,000 men and women, Palestinian prisoners in Israeli prisons. They are distributed over 22 prisons and camps and arrest centers in the State of Israel. This includes 476 detainees who are serving 1 or more life sentences. There are 19 women prisoners and 200 children prisoners under the age of 18. There are 185 people under administrative detention and 11 elected members of the Legislative Council, as well as a number of political leaders in prison. More than 30 prisoners have been in jail for more than 20 years, and notably Karim Younes, who has been in prison for 32 years. Israeli occupation authorities, since the beginning of occupation in 1967, have detained about 850,000 Palestinians, including all sectors of society: children, women, elderly people, youth, sick people, disabled people, members of parliament, academics, political leaders, trade union leaders, professional leaders, students, artists, writers, teachers, and others. Arrests are conducted daily. They are part of a routine practice of the occupation authorities. The total number of arrests in 2013 was 3,874 detentions. On average, every month, 323 cases of detention have been registered. That is about 11 cases of detention daily. 75% of detentions in 2013 13 were detentions of children under the age of 18. Ladies and gentlemen, we are hopeful about this meeting, particularly in this year where the United Nations declared this year as the year of solidarity with the Palestinian people. This meeting is important to settle the legal question as to the status of Palestinian detainees in international law. It is important to have a legal and political strategy with regards to detainees in Israeli prisons. This can help us set steps and priorities, prioritize steps to be taken in order to offer legal protection to detainees in line with international humanitarian law and address the gross violations that the detainees are subjected to. We hope that in this meeting we will rely on a number of legal parameters as follows. 1. The fact that Palestine became an observer state on the 29th of November 2012. Thus, it became a person of international law which regulates relations between states. This put an end to Israeli allegations that Palestinian territory is disputed, and this confirms all resolutions of the United Nations that it is an occupied Palestinian territory, occupied since 1967, including Jerusalem, and that it is the territory of the Palestinian state that is under Israeli occupation and must be liberated to enable the people of Palestine to practice their right to self-determination. 2. Palestine has acceded to 15 treaties and international conventions. That is on the 1st of April 2014. These are the 4 Geneva Conventions of 1949 and the first additional protocol to the Conventions on the Protection of Victims of International Armed Conflicts, the Hague Convention on the Respect of Laws and Norms of War, and the Regulations on Laws and Norms of territorial wars, the International Convention on Apartheid, the International Convention on the Elimination of Racial Discrimination, the Convention on Genocide, the International Covenant on Civil and Political Rights, the International Convention on the Economic, Social and Cultural Rights, the Convention Against Torture and other forms of cruel, inhuman or inhuman treatment or punishment, the Convention on the Rights of the Child, the UN Convention on Corruption, the Vienna Convention on the Law of Treaties, and the Vienna Convention on Diplomatic Relations, and the Vienna Convention on Consular Relations. The fact that Palestine signed these treaties and conventions implies that international laws become the reference, and Israel must be bound as a state that is the occupier state, must respect the provisions and principles of this convention in dealing with the Palestinian detainees in Israeli jails. The UN Charter and UN decisions have confirmed the right of the Palestinian people to self-determination as an inalienable right. Every member of the United Nations must preserve the right to self-determination of other nations. Bringing other peoples under foreign occupation, control, occupation, or colonization is a contradiction to the UN Charter. UN resolutions have systematically confirmed the right and legality of the resistance of peoples to acts that prevent them from achieving their self-determination, and have supported the movements of national liberation that aim at acquiring independence and liberating these peoples from foreign occupation and control. These last 3 points show that the Israeli allegations are incorrect and unsubstantiated. They refuse the application of the Geneva Conventions on the occupied Palestinian territories on the basis that they are not under a sovereign state and that no state have laid claims of sovereignty over this territory. The Fourth Geneva Convention only applies on the occupied territory of a high contracting party. Therefore, Israel has dealt with Palestinian detainees and prisoners as criminals and terrorists and has applied to them its internal laws and the whole system of military rules. This claim is now proven untrue since the Swiss government declared on the 11th of April 2014 that the State of Palestine has become a high contracting party to the four Geneva Conventions of 1949 and the first additional protocol of 1977 without any reservations. Furthermore, this proves the falseness of the Israeli allegation which refuses to recognize that Palestinian territories that are occupied are disputed, while the international law recognizes the legal personality of national liberation movements in line with UN resolutions and the additional protocols to the Geneva Conventions. The UN also accepted the membership of the Palestinian Liberation Organization as a national liberation movement as representative, sole representative of the Palestinian people as an observer since 1967, and also in the Declaration of Principles in 1993. Now, as for the factual situation of prisoners in Israeli jails, the government of Israel, as the occupying power, committed gross violations of international humanitarian law as well as war crimes and crimes against humanity in dealing with these prisoners. This is in contravention with the joint third article of the Geneva Convention and the first additional protocol as well as UN resolutions. And I would like to mention the most notable of these violations. One, detention of Palestinian detainees in the prisons of the occupying state, which is not in line with the the Fourth Geneva Convention, Article 76, 66 and 49, which prohibit the transfer of prisoners from the area under occupation to the occupying state. Secondly, the use of torture and humiliating treatment against prisoners in order to extract information from them. This is in contravention with Article 3 of the Fourth Geneva Convention, as well as the Convention against a Treaty of 1984, which considers all acts of torture as war crimes. 73 Palestinian prisoners have died since 1967 because of torture, the latest of which was the prisoner Arafat Jaradat on the 23rd of February 2013. Israel has been acting as a state that considers itself above the law, using cruel and barbaric methods of torture against prisoners, including children, from the moment of detention. Torture is given a legal aspect in Israeli laws and tribunals under the pretext of the fight against terrorism. Investigators have legal immunity. Not a single investigator or Israeli official has been held accountable or prosecuted for crimes committed against detainees during interrogation. The Israeli Supreme Court, which is the highest court in Israel, refuses to open any criminal investigations with regard to complaints made by prisoners or human rights organizations on the use of torture and beatings against prisoners. As one of the officers said, an officer in the investigations unit in Israel, and this was published in the Haaretz newspaper on the 8th of December 2012, he said that torture and beatings and the humiliation of detainees are methods that are used systematically, and they are not exceptional. They are not considered unacceptable in the unit where he works. Thirdly, the detention of children. Since 2000, 8,000 Palestinian children under the age of 18 have been detained. Israel continues to detain children until now and deals with them without protection, without respect for their rights. It does not abide by the CRC of 1990, considering that children are those who have not reached the age of 18. It deals with children on the basis that children are those who have not reached the age of 12. Annually, 700 children are detained. The youngest child detainee was only 8 years old. They are put on trial in military courts with adults, not in juvenile courts. 95% of children who have been detained have been subjected to humiliating treatment and investigation during their detention and their questioning. Confessions were extracted under duress with the use of intimidation, pressure, and threats. They are detained in cruel and difficult conditions. Some of them were subjected to sexual assault, solitary confinement, and were deprived of access to their lawyers. The British Foreign Ministry announced on the 26th of June 2012 with regard to the way that children are treated in detention. This came out in a report by a group of British lawyers. They said that children are detained in conditions that could be considered tantamount to torture, such as solitary confinement, deprivation of visits of family, deprivation of sleep, sexual harassment, having to sign confessions in a language that they do not speak. And Israel has dealt with every Palestinian child as a potential future terrorist. For medical negligence, the reports of human rights institutions have demonstrated the existence of the policy of medical negligence and the lack of treatment for sick detainees, which leads to them developing worse symptoms. 1,400 cases of ill prisoners have been registered, including 25 cases of cancer, as well as tumors, paralysis, disability, and bullet wounds. The medical policy in prisons is basically a policy of a procrastination in treatment and not transferring ill prisoners to hospitals, misdiagnosis, medical error, refusing to transfer patients in ambulances, the lack of specialists, harsh detention conditions, the use of repressive means that cause diseases such as tear gas. The Israeli science minister in 1997 declared that 1,000 medical experiments were conducted by Israeli pharmaceuticals against Palestinian detainees. This explains why there is such a high level of disease among the detainees. 53 Palestinian prisoners have died because of medical negligence since 1967, the last of which were Hassan Turabi and Maysara Abu Hamdiya. Now, administrative detention. Israel continues to resort to administrative detention against prisoners in an arbitrary manner, without trial, without charge. This detention is renewed continuously without giving a chance to the prisoners or their lawyers to defend them. In this, Israel relies on what is called the confidential files that are presented by the security Israeli forces. 180 prisoners have, under administrative detention, have started a hunger strike in protest against their continuing administrative detention. I would also like to tell you that 23,000 administrative detention orders have been issued against Palestinian prisoners since the year 2000. This includes all categories of Palestinian society, including elected members of the Palestinian parliament. According to this Israeli policy, administrative detention has become routine, not an exception. It is not an exceptional measure as is indicated in the Fourth Geneva Convention. Israeli occupation authorities resort to administrative detention as an easier way instead of criminal proceedings, as it does not have evidence to support the charges. It is now also the general rule to keep evidence confidential. Relying on confidential information shows that there is full trust by the court system given to the security apparatus in Israel. 6, lack of fair trial. The detention of Palestinians in the occupied territories and the way that these prisoners are dealt with is subject to a list of military orders issued by the Israeli military leaders. Palestinian detainees are tried in Israeli military courts, which are within military bases headed by military men. Israel refuses to apply the Fourth Geneva Convention on the Protection of Civilians during war in regards with trials. Scores of thousands of Palestinians have been put on military trials since 1967. The Israeli court system is inherently unjust and does not follow regular due process. The majority of Palestinians who are brought to these courts have been convicted. Out of 8,854 cases examined in military courts in 2006, only 26 cases led to an acquittal. Israeli occupation courts are also discriminatory. The maximum punishment in civil courts used against Israelis are less strict than those used against Palestinians. I can also give you examples of cases where Israel does not respect international laws in dealing with prisoners. There are many violations such as deportation, solitary confinement, preventing prisoners from meeting their families, apartheid, deliberate murder, abduction from territories under the authority of the Palestinian Authority, the use of Palestinians as human shield. And there are many other violations which the Geneva Convention prohibits. And according to the Geneva Convention, persons who are responsible for such serious violations should be either brought to court or sent to states that would be ready to prosecute them. Ladies and gentlemen, in this important meeting today, it is our hope that we will have a strategic legal vision on what mechanisms can be set up to offer protection for Palestinian detainees. I think that in this vision, we should start from the principle that the Geneva Convention is applicable, as international legal scholars have agreed that this convention does apply to the occupied Palestinian territory and to the Palestinian detainees in Israeli prisons, as the third convention applies the vast majority of the fighters of the PLO, as well as security officers of the Palestinian state and the security apparatus in the Palestinian Authority, since the PLO was declared in 1982 as a liberation movement and accepted the provisions of the first additional protocol to the Geneva Conventions. Therefore, we should look into the legal means that can make Israel, as the occupying power, bound by these conventions. Among these means that could be examined in this meeting, I would like to mention the following.
To call upon all the Geneva Convention high contracting parties to compel Israel to apply the 4 Geneva Conventions to the occupied Palestinian territories, as well as Palestinian prisoners and detainees, to apply the regime of the protecting power and to respect human rights and to protect the interests of victims, and to make sure that all parties to the conflict comply with international obligations and provide protection to victims and civilians in the case of military occupation, to examine to what extent the courts of the member states in the Geneva Conventions resort to the allegations of crimes of war which are committed by Israelis against prisoners, to study the prospect of establishing a special court by the General Assembly in accordance with the UN Charter, to examine the crimes of Israel against prisoners. 5, to examine the prospect of seeking the legal advisory opinion of the International Court of Justice regarding the status of Palestinian prisoners and the responsibility of the occupying power, to examine the establishment of a fact-finding mission composed of 15 members of the Geneva Convention in accordance with the first additional protocol, to investigate the situation of Palestinian prisoners, to study the importance of the Palestinians' accession to the Rome Statute as a step towards prosecuting Israelis for crimes against Palestinian prisoners. And finally, I would like to express to you once again my thanks and wish this meeting success in order to restore justice, freedom and peace to the Palestinian people and our prisoners in the Israeli prisons. Thank you.
Je remercie.
I would like to thank His Excellency Mr. Issa Karange for having accepted the task of presenting or representing the State of Palestine during this meeting. Your message stresses the importance that the Palestinian government attaches to the work of the committee and the United Nations organization, and stresses yet again the need to resolve in a just and balanced way the question of Palestinians that are still detained in prisons and detention centers in Israel. I would like to use this opportunity to express through you to Mr. Mahmoud Abbas, the President of the State of Palestine, the assurances of our respect and our solidarity with your people in these difficult times. Ladies and gentlemen, we thus concluded the work of the opening session of our meeting, and I'd like to thank the speakers for their statements that will be guiding our work during the upcoming sessions. Now, these discussions during the upcoming sessions will be guided by our moderators, Mr. Hugo Foster Pocard, here present at the podium, the president of the ICTY, Professor William Shabas, the Middlesex University of London, Mr. Paul Tavernier, Professor, Université de Paris 11, and Miss Flavia Latanzi, Judge of the ICTY. Now, I'd like to say that the upcoming sessions, including the last session, will be closed sessions. So I'd like to ask any of the observers and representatives of the press are requested to leave the room. So we'll be suspending the meeting for a few moments.